Parker were on the Lacrone Loop overlook, correct?
Yes, ma'am.
And that was at 4:30?
Approximately, yes.
But you also took a statement from Mr. Cameron Lee, correct?
Yes, ma'am.
Cameron Lee informed you that he saw Jordan Ryder crossing a bridge.
Yes.
And that was at about 4:30.
Slightly after 4:30.
But that's the time he gave you, 4:30.
Approximately.
And that bridge is about right there.
Yes, ma'am.
You also took a statement from Armani Rodriguez.
That is correct.
And he saw Jordan and Parker near 4:30.
Mr. Rodriguez saw them around 4:30 as well.
And that was near the beginning of the trail.
That is correct.
So that would be about right there. Right?
Yes, ma'am.
So at 4:30, Kelly Dews said Jordan and Parker were there.
That is what Mr. Deuce said.
And at 4:30, Cameron Lee and Armani Rodriguez said they were right there.
Objection to argumentative, Your Honor. May I explain?
Sure.
Your Honor, this witness, when she was originally asked this question about when they were seen at the bridge, stated that it was approximately 4:30, which means a little bit before, a little bit after, that they saw the defendant at the bridge. Now, for opposing counsel to say, so at 4:30, they said that they saw them at the bridge as her testifying and mischaracterizing Detective Chesney's statement.
If Detective Chesney doesn't believe that it was actually at 4:30, she's more than welcome to respond that it was about that time.
I'm gonna overrule the objection. I think it's cross-examination. She can put words in the witness's mouth. She needs to correct that if she thinks it's inaccurate. You also have a chance to redirect her. So I'm gonna overrule the objection.
Yes, Your Honor. And at 4:30, Cameron and Armani said they were here.
That is where they said they were.
That's 3 miles apart, right?
Approximately, yes.
So you have two completely different stories of where Jordan and Parker were at 4:30.
Well, ma'am, like I said, approximately 4:30. Now, Mr. Deuce likely saw them prior to 4:30, and Armani and the other witness, Mr. Lee, likely saw him approximately after 4:30.
Just a little bit after 4:30, correct?
Probably slightly after, a few minutes.
So Jordan and Parker could have made it 3 miles down the Lacrone Loop in a few minutes.
Well, Miss Ryder could have.
Parker could have as well.
Parker likely could not have.
Armani Rodriguez saw Parker as well.
Well, it would have been difficult for Parker. Now, if they had plenty of time, if Mr. Deuce was slightly off or Armani Rodriguez was off, it would have been possible.
Now, it's still your contention that Jordan Ryder could hike 3 miles in a couple minutes?
Downhill, that would be correct.
All right. Now, I want to talk about what happened the next day. As of 10 a.m., July 15th, you hadn't yet found Parker's body.
Not yet.
You didn't know Parker was dead.
Not yet. We were looking for her as a missing child.
You had no reason to believe that Jordan killed Parker.
Not yet.
You had no probable cause to believe that Jordan hurt Parker in any way.
We had not started the official investigation yet, so we did not have any probable cause, no.
But you arrested Jordan.
For a completely different reason, for violating her parole.
That's right, you arrested Jordan because you thought she violated her parole.
That's correct.
Detective, you never received a copy of that parole violation.
No, we did not.
You can't tell us the terms of that parole.
She was not allowed to be there with her child without Mr. Dallas.
You just said you never received a copy of the parole violation.
No, ma'am.
So you can't tell us the terms of the parole.
I can't tell you the specific terms of the parole.
So you don't even know that Jordan was violating her parole.
Well, she was violating the parole after we sent it in. She was in violation, and that is why we were allowed to take her into custody.
When you interrogated Jordan Ryder, correct?
That's correct.
You never once asked her about that parole violation.
No, ma'am.
Thank you. With that, I have no further questions. Would opposing counsel like me to remove the demonstrative?
Will you redirect?
Yes, Your Honor. Detective Chesney, when you were conducting your investigation and taking those witness statements, at any point, did you find any evidence to point to a different suspect?
No, ma'am. All of the evidence we collected, physical or eyewitness testimony, pointed directly to Jordan Ryder.
Did the times that those eyewitnesses gave you for seeing the defendant, were they contradictory?
No, ma'am.
Thank you, Detective Chesney. I have no questions.
Any recross?
No, Your Honor.
Thank you. You can step down. All right, defense, prosecution ready with a second witness.
Yes, Your Honor. At this time, the prosecution calls Kelly Deuce to the stand.
Mr. Hughes?
Before I begin, may I approach the bench to retrieve Exhibit 17?
Okay.
It's, I can say.
Well, that's that.
Yeah.
Okay.
Thank you.
May I proceed?
Okay.
Please state and spell your name for the record.
Well, good morning. My name is Kelly Dews. That's Kelly spelled normally, and then Dews, D-O-O-S.
What do you do for a living?
Well, I'm a part-time travel writer, explorer, content creator, and thrill seeker on top of that. I'm lucky enough to be able to make a living loving what I do, and what I love to do is document beautiful places and amazing people doing things in those places.
We've heard about Calkins Campground in court today. Have you ever been to that place?
I did get a chance to make it to Midlands and Calkins Campground in July of 2018. I planned on videotaping parts of the trails, taking some pictures, and I guess creating content there. I guess that's not quite how that weekend turned out though.
We'll talk about that weekend and what actually happened a little bit, but first, are you familiar with Jordan Ryder?
Yes, I am. I met Jordan Ryder at Calkins Campground, so, her and her daughter on a trip when I went.
Do you see Jordan Ryder in this room today?
Yes, I do.
Could you identify Jordan Ryder by a piece of clothing?
Yes, she's wearing a brown sweater and a longer skirt.
May the record reflect that the witnesses correctly identified the defendant.
Who won?
Mr. Hughes, could you tell us a little bit more about the first time that you met the defendant and her daughter?
Of course. Well, at Calkins Campground, I had planned on going hiking on some of the trails surrounding the campground itself. I chose the Left Roan Loop for one trip, and I met Miss Ryder and her daughter on an overlook of one of those trails. It was this big, beautiful open clearing where you could see the entire campground, the forest. It was a beautiful sight.
What did the defendant and her daughter appear to be doing when you saw them?
They weren't really hiking, I guess, even though they were on the hiking trail. It was more just they were stagnant, I guess. I thought at first it might be to just appreciate the massive view that was right there, but they were just yelling at each other and fighting.
You said they were fighting. Could you tell us a little bit more about that?
Yes, they were standing in the same spot, just yelling at each other. Jordan kept saying, "Quit it, quit it, quit it," to her daughter. And Parker had this hiking stick that she was holding, and she kept whacking, hitting, and jabbing it all over on tree roots, rocks, dirt. And she even jabbed it into Jordan's cap.
You just said that Parker Page jabbed her hiking stick at the defendant's calf. What happened next?
Well, what happened next was Jordan, she kind of took the hiking stick. It was, I don't know, there was a lot that happened. It was kind of a lot of movement. I could probably show you, honestly, better than I could tell you about it, if that would be okay.
I'm approaching the witness with what has previously been marked as Exhibit 17. Mr. Dews, what is that?
This is that hiking stick that Parker Page had that day.
How do you recognize it?
Well, I mean, it's the exact same handle, same color, and all the markings are the exact same on it, too.
Does it appear to be in substantially the same condition as the last time you saw it?
Yeah, it's the exact same since I saw it.
At this time, may the witness step down to show the court exactly what he saw happen with Exhibit 17?
Yes.
Mr. Dews, do whatever you need to make this as accurate to what you saw as possible, okay?
Okay. Well, if I was Jordan Ryder and then you were Parker Page, what had happened first was, well, Jordan Ryder took the hiking stick from her daughter right away. And I guess the way she took it from her daughter, she took it so forcefully from her daughter that she just about fell over, just like that. And while Parker was falling over, Jordan, she took the hiking stick and turned it around on her daughter. Through gritted teeth and everything, she took it and jabbed it at her daughter, just like that. Barely missed her, too. She almost knocked her daughter to the ground.
Thank you, Mr. Dews. You can take your seat.
Thank you.
After witnessing this interaction between the defendant and her daughter, did you see them again?
I did. I saw him one more time, and I did hear from her daughter, Parker, one more time as well.
And could you tell us about the time that you saw them again?
The next time I saw him, it was after I decided to kind of venture off the path. I went into the woods and thought there might be some good shots out there, but I came back right to the opening, and I saw them in the exact same spot, still doing the exact same thing. So it was some time later.
And what was the second time when you said you just heard them?
Well, after I had gotten back to the path, I decided to continue up the trail. There was a peak or a summit at the end of it. It was a little while after I had left them at the overlook that I heard Parker unmistakably just screaming. And there was just after that, just one sharp, pained shriek almost.
So just to be clear, Mr. Dews, when was the last time that you saw Parker Page alive?
Well, the last time I saw her alive was, well, it was just above where they found her lifeless body, just at the bottom of the Hawkins Rock Overlook Cliff.
Thank you, Mr. Dews. I have no further questions. I'm approaching the witness to retrieve Exhibit 17. May I first bench attendant?
Cross-examination?
Yes, Your Honor, before I begin, may I set up the well for use of the demonstrative?
You may.
May I proceed? Good morning, Mr. Dews. My name is Kelsey Hall. I'm just going to be asking you a few questions on behalf of Ms. Ryder today.
Good morning.
Mr. Dews, you'd agree with me that when it comes to today's case, you don't have very many answers, do you?
I don't know what you mean.
Well, you don't know how Parker died.
I think I have a pretty good idea. She fell off a cliff.
You weren't there when Parker died.
No, not in viewing distance, no.
You can't tell us when Parker died.
Not exactly sure, no.
You're familiar with the Calkins campground, right, Mr. Dews?
said, I had a trip there last July.
Right, you visited on the weekend of July 14th.
I did.
So you'd recognize the Calkins campground if I showed it to you.
Yes, I did.
Mr. Deuce, you'd agree with me that the Calkins campground is in a pretty rural area, right?
Yeah, for the most part. That's kind of what makes camping so great.
Right, it's kind of in the middle of nowhere. In fact, Mr. Deuce, it's difficult to get cell phone service at Calkins campground, right?
Yeah,
You'd agree with me that the only time that you were able to get cell phone service was right here at the picnic area, right?
not, so you didn't really circle the picnic area. You circled kind of the entire campsite.
Well, you'd agree with me that this insert is where the picnic area is at, right?
Yes, but I guess more specifically, it was only the little spot on the enlargement.
Okay, so at the picnic area.
Yeah.
That was the only time that you were able to get the cell phone service.
Yeah, it went from absolutely no service to 4 bars out of nowhere. It was crazy.
Right, Mr. Hughes, you hiked several trails that day, right?
Yeah.
Including the Lacrone Loop.
I did.
You couldn't get cell phone service on the Lacrone Loop.
No.
Couldn't make calls,
Again, no, that's kind of the best part of camping.
couldn't send text messages.
No.
So let's talk about those 2 interactions that you had with Miss Ryder and Parker on the day of July 14th.
Okay.
So the first interaction you had on the Lacrone Loop, right?
Both of them, I think.
You'd agree with me that you started here to hike the Lacrone Loop, right?
That's correct.
You walked for about 20 to 30 minutes, right?
Yeah, it was something like that.
And that's when you began to approach the overlook, right?
That's right.
And that's when you saw Miss Ryder and Parker.
Yes.
And like you testified on direct examination, you saw Miss Ryder take that hiking staff away from Parker, right?
I did.
But like you testified on direct examination, Mr. Dews, I want to be clear, Miss Ryder only took that hiking staff away from Parker after Parker was jabbing it in the direction of Miss Ryder.
Yes, it was chronologically, it was after that, yeah.
So then you walked away from them, right?
I did. The part you circled too is kind of a really big stretch of trail as well.
Well,
The
this,
overlook's not that entire area, I guess.
well, this is the overlook, right?
Yes.
You were approaching the overlook, right, Mr. Dews, when you saw Miss Ryder and Parker that first time?
Yes.
And then you had walked away after the interaction.
I did. Like I said, I went off into, kind of off the path.
So then you saw them again at about 4:25.
Somewhere around there.
Right, and when you saw them again, Parker had the hiking staff.
She did this time.
It wasn't Miss Ryder holding the hiking staff.
No, she must have given it back to her.
You decided to leave them alone again, right?
I mean, I just wanted to keep hiking up the trail, I guess.
Right, so you walked about 15 minutes away
This is true. Yes.
through heavily wooded area.
Well, it was the trail.
It was a heavily wooded area, right, Mr. Dews?
Yes, on either side of the trail, yes.
Right, it was so heavily wooded that you couldn't see Parker,
No.
you couldn't see Miss Ryder,
No, I walked away from
and that's when you heard a scream, right, Mr. Dews?
it. Yes, I heard Parker screaming that she wished her mother had gone back to jail, that she didn't care about her, really.
I want to be clear, Mr. Dews, you don't know where that scream came from, right?
It came from Parker.
But you don't know where the location of where that scream came from.
The last place I saw Parker would have been the overlook, so somewhere close to there, obviously.
But you don't know that, do you, Mr. Dews?
No, just where the Parker was.
Right, because you had walked 15 minutes away.
That's true.
And like you had testified, it took you only 20 to 30 minutes to get from the overlook to the picnic area. Or to the trailhead, I'm sorry.
Yes, so wherever she was, it was from Parker.
So let's talk about July 15th, Mr. Dews.
Okay.
You testified on direct examination that you actually led the police officers to where Parker's body was found.
Yeah, the morning of July 15th, I was riding in my cabin. I heard the sirens, and one of the detectives showed showed me a picture. I kind of put it together that that was the missing girl, and I took him to the last place I had seen her alive.
When you took the police officers to find Parker's body, you heard the police officers making condemning statements toward Miss Ryder.
Objection, Your Honor, to hearsay as to the statements made by the police officers.
Yes, Your Honor. While there hasn't been any specific statements that are elicited, we're not using this for the truth of the matter asserted. Rather, we're using this to show a bias of the police department against Miss Ryder in today's case. The specific statements that are going to be elicited are that I can't believe Jordan Ryder would do this. Jordan Ryder should have never gotten out of prison. And we're not using this to show that Jordan Ryder should have actually never gotten out of prison, but rather the bias of the police department against Miss Ryder.
Your Honor, if they're using these statements to show the bias of the police officers, then they are using them for the truth of the matter asserted. That the police officers did believe these statements, and that these statements were made by the police officers against Jordan Ryder. They're using these for the truth of the matter asserted. This is inadmissible hearsay.
Yes, Your Honor. Like I said, we're not using this to show that the police officers actually believe that Jordan Ryder should have never actually gotten out of prison, or that they couldn't believe Jordan Ryder had actually done this, but that there could have been a bias from the police department against Miss Ryder in today's case.
Any other response to that?
Your Honor, I would still say that as they're using this for the bias of the police department, that they are using these statements for the truth of the matter asserted.
Are these coming from officers as opposed to Detective Chesney?
They are police officers working with Detective Chesney.
And your specific question is whether or not you heard those statements?
Yes.
I'm going to overrule the objection.
Mr. Dews, when Parker's body was found, you heard the police officers making condemning statements towards
Objection,
Miss
Your Honor,
Ryder.
to argumentative by the use of the word condemning. Without hearing these statements, opposing counsel cannot testify that these were condemning statements.
Mr. Dews, when you found Parker's body, you heard the police officers saying that they couldn't believe Jordan Ryder did this.
I may have heard one of them say that.
That's a yes to my question. You heard a police officer say that.
Yeah.
You heard a police officer say that Jordan Ryder should have never gotten out of prison.
Yeah, after seeing what she had done, I understand.
This is before you even saw the police officers arrest Miss Ryder.
That's correct.
Thank you, Mr. Dews. At this time, Your Honor, I have no further questions. Would opposing counsel like me to deconstruct the demonstrative?
There is no redirect, Your Honor.
Thank you, Mr. Bell.
Thank you.
Prosecution, are you able to file with us?
Yes, Your Honor, the state calls Dr. Quincy Dixon. Your Honor, before I begin my direct examination, may I approach the bench to retrieve Exhibit 17?
Yes.
medical examiner at Breckenridge County.
What do you do as the chief medical examiner?
I perform autopsies to determine the time and cause of death.
Is this the only position that you've held in your field?
No, I've been in the field for about 20 years now. In addition to teaching, I was also the assistant medical examiner before becoming the chief medical examiner.
Have you done anything notable in your field?
I have written peer-reviewed publications. In addition, I received the Governor's Medical Medal of Honor in 2018.
Dr. Quincy, what's your education?
I received my MD from the University of Virginia School of Medicine.
How are you involved in today's case?
I examined the body of Parker Page.
Did you have a method when doing your examination?
To determine the cause of death, I use what is known as the EIE method, which stands for external, internal, and then evidentiary. To determine the time of death, I use the standard T-box formula with modifications.
Have you conducted autopsies in the past?
Yes, I have.
And did you use the same method you just described in those other autopsies?
Yes, I did. It's a reliable method.
And did you apply that method in the past the same way in today's case?
Yes, I did.
Did you have everything you needed to conduct Parker's autopsy?
Yes, I had access to Parker's body in addition to past medical records and some evidence provided by Detective Chesney.
How did you begin the autopsy of Parker Page?
I started with the fourth step in the EIE method, which is the external examination.
And what is an external examination?
In an external examination, you look at a body for things such as bruising, abrasions, lacerations, or any other abnormalities.
What did you find during Parker's external examination?
The right side of the body was covered in bruisings, which is consistent with a fall from a 40-foot cliff onto the right side. However, there was one isolated bruise on the left shoulder blade, which was troublesome to me.
Why was that isolated bruise on Parker's left shoulder bone troubling?
Well, again, there was bruising on the right side, which indicated she fell onto the right side of her body. There would be no damage expected on the left side, but there was.
Objection, Your Honor, to an improper opinion. May I explain why?
Sure.
While this witness did detail that she had a specific method, we believe that there's been a lack of foundation laid as to whether or not these methods are reliable. If I could turn your attention to Midland's case law, Terry Readers Association versus Vero Dow, it states that it's not enough for a witness simply to state that their method is reliable. We have to hear things such as unknown error rate, whether or not these methods have been peer-reviewed, widely accepted in the field, as to determine whether or not these methods are reliable in the field of science as a whole. And we haven't heard that from this witness yet.
Yes, Your Honor. The same case opposing counsel just mentioned. It also states that these factors, while relevant, are not necessarily dispositive. I've already asked Dr. Quincy if she's used this method in the past in other autopsies. I've also asked her whether or not she used that same method that she's used in the past in this exact case, and she said yes. She also said that she applied that same method the same way that she has in the past. Dr. Quincy would not be using that same method in the past if it was unreliable. Moreover, we've heard Dr. Quincy's previous work in the field. She's obviously been in the field for 20 years and has grown her medical experience enough to know whether or not the methods that she's using is reliable.
May I respond? Your Honor, simply because Dr. Quincy has used these methods in the past doesn't mean that she hasn't made errors using these exact same methods in the past. It's important to note that if Dr. Quincy has been in this field for 20 years, she would be aware of whether or not her methods are peer-reviewed and widely accepted in the field. And it's important for the members of the jury to hear those things when determining whether or not her methods are credible.
Your Honor, may I be heard?
Yes.
Now, opposing counsel just asked whether or not Dr. Quincy applied that method correctly in today's case. Now, if opposing counsel actually wants to talk about that, then they can do that during their cross-examination.
Well,
However,
potentially, but by that time, it's already in, right? I mean, what he's trying to do is keep it out before he has to do the cross-examination. I think you have to lay that foundation. She may not have, She may have done this for 20 years. She may not be very good in her field. We don't know that yet, if she hasn't tested these methods and proven those methods. So I'm going to sustain the objection.
Yes, Your Honor, motion to strike until that foundation's laid.
I will strike that.
Dr. Quincy, you mentioned that you were in the field for 20 years. Have you received any awards in your field?
Yes, like I previously mentioned, I received the Governor's Medical Medal of Honor in 2018.
What do you know about the Governor's Medical Medal of Honor?
It's a prestigious award for somebody in my field.
Does every expert in your field receive the Governor's Medical Medal of Honor?
No.
Dr. Quincy, how did you begin the autopsy of Dr. Quincy? What did you do after completing your external examination?
Well, after again noting the irregular bruise on the left shoulder blade, I began the second step of my method, which is the internal examination. In this, we look at any breaks, fractures, and bones, along with the toxicology report.
What did you find during Parker's internal examination?
Again, the right side of her body showed extensive damage, such as breaking and fractures in the bones, which is again consistent with a fall onto the right side of her body. However, there was still an abnormality in that the left shoulder blade was broken.
And why was that left shoulder blade being broken abnormal?
Again, only damage on the right side of the body would have been expected in a fall. The left shoulder blade was unexpected.
Dr. Quincy, is it possible that Parker could have broken her collarbone after the fall?
No. The bruising on the left shoulder blade was lighter than the bruising on the right side of the body, which indicated it had to have occurred prior to those bruises. Additionally, the left shoulder blade was directly underneath where the bruising occurred, which indicated they occurred at the same time.
What did you do after completing the internal portion of the autopsy?
I then moved on to the third and final step in the EIE method, which is the evidentiary examination. External evidence can often tie pieces found on the body together. In this case, I received some items from Detective Chesney, most notably a walking stick.
Let the record reflect that I am approaching the witness with what has been marked as Exhibit 17. Dr. Quincy, what is it that I just handed you?
You have handed me the walking stick I received from Detective Chesney.
Is it in substantially the same condition as when you analyzed it during Parker's evidentiary examination?
Yes, it is.
Is it possible that that walking stick could have caused the isolated bruise on Parker's left side of her body?
Yes. If you look at the top here, this shape is the same size and shape as the bruise found on Parker's body.
Did you measure the capped end of that walking stick?
Yes, I did. The diameter was 2.25 centimeters.
Did you measure the bruise on Parker's left side of her body?
Yes, the diameter of that bruise was also 2.25 centimeters.
Is it possible that that walking stick could have broken Parker's collarbone?
Certainly, with enough force from a jab, it is very possible that it could have broken a collarbone.
You previously mentioned that you also calculated Parker's time of death. What did you find there?
Using the body temperature at the time of the examination, along with the standard heat loss formula with modifications to account for the environmental factors, time of death was between 4 and 6 p.m. on July 14th.
Objection, Your Honor, to an improper opinion once again. May I explain?
Sure.
Your Honor, while we did hear this doctor detail her method as in finding the cause of death, she didn't detail a method that she uses in determining time of death. She just elicited testimony as to as to what the time of death for Parker Page was, without laying the proper foundation necessary for the members of the jury to hear to determine how she came to that conclusion. I just asked that that foundation be laid.
Your Honor, may I be heard? That foundation has already been laid. This witness already testified that she used a standard time calculation for death that is used within her field. And so that foundation has already been laid, considering that she talked about what that calculation was and that she's used it previously as with the other EIE method and that she used it the same way in today's case.
May I respond to that, Your Honor? It's not enough for this witness to simply state that she used a standard formula. We need to hear what the aspects of that formula were, how she went about finding those different aspects of that formula, and whether or not we can determine whether or not how she went about finding those aspects of the formula are actually credible. This witness can't just simply state that she used a standard formula. The members of the jury need to hear the facts as to how she went about finding these different aspects of that formula. And that's the foundation that hasn't been laid yet.
Your Honor, that's not necessarily true. Once again, opposing counsel brought up case law, and from that same case law, I read that those factors are not dispositive. While they can be helpful, they're not dispositive. We've already laid the necessary foundation for this witness to talk about that time of death. All she mentioned was that the different portion of the equation she used was to measure environmental factors, and that can be relative to each case.
May I respond briefly, Your Honor? I agree with opposing counsel that this list of factors isn't dispositive. It's not a definitive checklist in which each and every aspect has to be met. But Dr. Quincy not stating a single one of these reasons as to why her methods are credible is most certainly an issue for the members of the jury. They must hear how she went about finding this time of death rather than her simply stating that she found a time of death using a standard formula. We need to hear the aspects of that formula and what she did to conduct an investigation in finding those aspects.
And you haven't asked her about that yet, right? You haven't had her go through the factors and discuss what they are, discuss the reliability,